Welcome to the world of New York real estate, where Article 12 serves as the bedrock for every professional transaction. In this chapter, we will lay the essential groundwork by exploring the licensing mandates and regulatory architecture governed by the Department of State. This content is for informational and entertainment purposes only and does not constitute legal advice. Furthermore, this is an unofficial, independently produced educational guide. It is not affiliated with, endorsed by, or connected to the New York Department of State or any official state testing authority. Always consult with qualified legal professionals or the relevant licensing board regarding your specific professional requirements. If you're aiming to pass the state examination on your first try, you've come to the right place. This course is meticulously designed to distill complex legal statutes into intuitive, actionable knowledge that sticks. By the end of this journey, you will possess a complete mental framework for navigating New York's rigorous professional environment. We cut through the noise, leaving you with exactly what you need to master your licensing requirements and succeed. Our focus begins with the Department of State's role in overseeing the industry through the lens of Article 12A of the Real Property Law. This legislation acts as the constitution for real estate practice in New York, defining the precise requirements for obtaining and maintaining a license. You will learn to clearly distinguish between the roles of a broker and a salesperson, which is a fundamental distinction that informs every aspect of your professional liability. We will examine how the Secretary of State enforces these standards to maintain consumer protection and orderly market operations. The exam is structured to test your grasp of these legal compliance protocols rather than your ability to memorize minutiae. So we focus on the core logic behind the rules. Beyond the basic requirements, we will address the operational realities of your career, such as license renewal cycles and mandatory continuing education standards. Staying active in this industry requires more than just passing a test. It demands a disciplined adherence to professional integrity and ethical conduct. Throughout this chapter, I will provide you with strategies to organize your study hours, helping you anchor abstract legal definitions to concrete real-world scenarios. We will look at how regulatory mandates impact daily tasks, ensuring you recognize not just the what, but the why behind each administrative code. You will find that approaching these requirements as a logical system, rather than a list of arbitrary prohibitions, significantly improves your retention. Consistency is your most valuable asset when facing the state examination. I encourage you to look at each topic not as a hurdle to jump, but as a component of the professional standard you are committing to uphold. By mastering the distinction between the roles of a broker and salesperson early on, you prevent future confusion regarding responsibility and accountability. We are here to ensure that when you sit down for the exam, you have a clear, calm understanding of the law. Let's get to work building that expertise. I look forward to our next session together. Welcome back to our journey through Article 12A, where we will now establish the essential framework for obtaining and maintaining a real estate license in New York. We are about to strip away the complexity and look at the precise requirements mandated for professional practice. In this chapter, we explore the rigid entry requirements defined by Section 440 of the New York Real Property Law, which serves as the gatekeeper for the industry. To operate as either a real estate broker or a salesperson for compensation, one must navigate a specific set of statutory hurdles designed to protect the public. The law is quite explicit that engaging in brokerage activities, such as negotiating sales, exchanges, or rentals of real property, requires a valid license. If you attempt these activities without proper authorization, you fall outside the bounds of the law, which carries serious consequences. Practicing unlicensed is not merely a technical error, but a definite violation of state law that can lead to misdemeanor charges. Beyond the criminal implications, it effectively strips you of any legal standing to collect a commission for your efforts, which is a powerful deterrent against informal or unauthorized practice. The baseline for qualification begins with age and legal status, functioning as the fundamental bedrock for any applicant. A salesperson must be at least 18 years of age, while a broker is required to be at least 20 years old at the time of application. Citizenship or legal residency is a mandatory component, ensuring that the Department of State can regulate those operating within our jurisdiction. Educational prerequisites involve the completion of a state-approved 75-hour qualifying course, which serves as your theoretical introduction to the profession. Once you complete this instruction, you must pass the state-administered licensing examination by achieving a score that demonstrates professional proficiency. It is important to remember that passing the exam is only the first step in a broader application process. You must also satisfy the Department of State regarding your trustworthiness and competency, a standard that evaluates past criminal history and professional character. Maintaining your status within the industry requires more than initial testing. It demands a clear understanding of active versus inactive licensure. When you're sponsored by a licensed broker, you hold an active license, which legally empowers you to perform the functions of a licensee for compensation. If you depart from your sponsoring broker and do not immediately transition to a new one, your license may effectively become inactive. You cannot practice or earn commissions while in an inactive state, as this would be tantamount to operating without a license. This distinction matters because the state regulatory body expects total transparency regarding who is currently authorized to facilitate transactions. Monitoring your own status, specifically ensuring your registration remains current, is a prerequisite for professional survival. Failure to maintain an active, properly supervised status creates legal vulnerabilities that compromise your reputation and legal standing. For those coming from outside of New York, the regulatory landscape includes provisions for non-resident licensing through reciprocity agreements. New York creates these paths by recognizing the standards of specific states, such as Pennsylvania or Connecticut, provided those jurisdictions extend similar privileges to our residents. The mechanism for this is mutual recognition, meaning that if you satisfy the requirements in your home state, you may be eligible to apply for a reciprocal license here without repeating the entire New York qualifying sequence. However, you must remain diligent about the specific mandates of the Department of State, as these agreements are not universal and depend on current executive actions. You are also expected to designate the Secretary of State as your agent for receiving legal process, which ensures that out-of-state licensees can be held accountable within New York courts if disputes arise. Always verify the current standing of these specific agreements, as regulatory relationships between states can evolve based on administrative policies. Transitioning from initial qualification to daily operation requires you to internalize these rules as a matter of routine conduct. The state does not provide these requirements to be cumbersome, but rather to ensure that every individual dealing with consumer assets meets a verified threshold of capability. Trustworthiness is a subjective but rigorously interpreted standard. The Department of State reserves the right to deny or revoke licenses based on evidence of poor ethical character. This duty of trustworthiness continues throughout your career, not just at the moment of your first application. By adhering strictly to these foundational requirements, you shield yourself from the risks of unlicensed activity and ensure your commission rights remain protected. Always treat these regulatory milestones as the professional minimums they are, rather than optional guidelines, because the legal system treats them as non-negotiable mandates. Integrating this knowledge into your practice establishes an ethical baseline that serves as your strongest defense in any real estate transaction. See you in the next lecture. Welcome back. Let's begin our examination of the statutory categories defined under Article 12A and how these distinctions dictate your professional path in New York real estate. In New York, the distinction between a real estate broker and a real estate salesperson is fundamental to your legal standing and operational capacity. A real estate broker is the primary license holder, possessing the legal authority to enter into contracts, manage escrow accounts, and supervise other licensees. Conversely, a real estate salesperson must operate under the direct supervision of a sponsoring broker at all times. Think of the salesperson as an extension of the broker's business entity, where the broker remains legally responsible for all professional actions taken by the salesperson. This hierarchy is not merely a formality, but a rigid regulatory framework that dictates who carries the liability for real estate transactions. When you become a salesperson, you do not have an independent license to conduct business alone. Your professional existence is tied to the license held by your sponsoring broker. Within the broker category, New York law accommodates various business structures through specific licensing paths. An individual broker manages their own affairs, but the law also recognizes trade name brokers, partnerships, and corporations as distinct legal entities. If a broker chooses to conduct business under an assumed name, that name must be properly registered with the Department of State to ensure transparency for the public. Corporations and partnerships must appoint one of their officers or members to represent the entity as the licensed broker, which creates a specific line of accountability. This representative must meet all standard education and experience requirements, essentially becoming the proxy for the firm's legal compliance. Even in these complex structures, the essence of the broker's responsibility to supervise, manage, and account for funds remains unchanged. A common point of confusion arises with the role of the associate real estate broker, who is an individual who has met all the requirements to be a broker but chooses to work under someone else's license. This person is essentially a highly qualified professional who prefers the administrative or operational support of a larger firm over the burdens of independent brokerage. Despite their advanced qualifications, legal, and educational standing, they remain subject to the supervision of the firm's principal broker. They are not authorized to open a branch office independently or act alone in the capacity of a principal broker. Their license status is legally distinct from that of a standard salesperson, yet their operational dependence on the sponsoring broker dictates their day-to-day work environment. This distinction is crucial because it clarifies that being an associate broker does not grant you the right to sever your ties to the principal broker's oversight. The role of the office manager is another area where the Department of State enforces strict supervision rules to prevent unauthorized activities. An office manager may handle day-to-day operations, but the underlying responsibility for everything occurring within that office belongs to the broker of record. If you're operating a branch office, the principal broker remains tethered to those locations, and they are responsible for ensuring that all licensees in that branch comply with state regulations. You cannot delegate the legal responsibility for supervision to a non-licensed manager or a salesperson. The broker must maintain a clear presence, even if that presence is administrative, to oversee the professional conduct of everyone under their umbrella. Mismanagement at the branch level is viewed by the state as a direct failure of the principal broker, who holds the ultimate license. Professional standards require that all licenses be displayed prominently at the principal place of business, which serves as a notice of the broker's compliance to the public. If you move your business or change your name, the Department of State requires immediate notification to update the official record. This is not just a filing requirement, but a mandatory legal step to ensure that the public has accurate information about whom they're dealing with. Failure to maintain current information can lead to disciplinary actions, as the state views accurate documentation as a pillar of consumer protection. Whether you are an individual broker, a member of a partnership, or an associate broker, your license reflects your current status and location. By keeping these records current, you demonstrate your adherence to the administrative duties that keep your license valid and your business reputation intact. I will see you in the next lecture. Welcome back as we transition into the specific requirements concerning your professional credentials and the legal necessity of your identification while in the field. This chapter focuses on the mandatory documentation that justifies your standing as a licensed practitioner in New York. In the state of New York, Section 441 of the Real Property Law mandates that every real estate licensee, whether they are a broker, associate broker, or a salesperson, must possess a legitimate pocket card. This document serves as the primary instrument for verifying your identity and authorization to conduct real estate activity. While your wall license is something that remains prominently displayed in your principal place of business, the pocket card is your mobile authorization. It is essentially your portable evidence that you have satisfied all the regulatory requirements. It is a vital component of your professional carriage, and you are legally obligated to carry it with you at all times when engaging in any real estate transactions. Whether you are showing a property, hosting an open house, or meeting with a client, you must have this card on your person and be ready to produce it upon request. The physical construction of the content on this card is standard and intentional to ensure that a member of the public or an official can easily verify your status. The card conspicuously displays your full legal name, your current business address, and your unique license identification number. This information allows any individual to cross-reference your status with the Department of State database to ensure that your license is active and in good standing. The distinction between a wall license and a pocket card is fundamental because the law treats them as serving different oversight purposes. The wall license must be held at the specific location where you conduct your main business operations to inform the public of your license status at that venue. Conversely, the pocket card provides the flexibility of practice, and failing to produce it when demanded by a client or a law enforcement officer is a direct violation of regulatory protocols. If you ever find yourself in the unfortunate position of losing your pocket card, or if it is stolen, you must move quickly to address the gap in your compliance status. New York has modernized this process through the eAccess NY portal, which allows licensees to manage their credentials online. The replacement process is straightforward, but it is necessary to emphasize that you should not delay in ordering a duplicate if your card is missing. Operating without the physical or digital card available for presentation is a liability that places your license and your reputation at risk. The law does not permit a grace period for carrying identification, so you should treat the card as you would treat a driver's license. By keeping this documentation updated and available, you maintain the transparency required by the Department of State and demonstrate that you are a practitioner who values regulatory adherence. When a member of the public asks to see your credentials, they're exercising a right afforded to them under New York law to ensure they're dealing with a vetted professional. Refusing to produce your pocket card or claiming that you do not have it on you can create unnecessary suspicion and legal friction during what should be a routine interaction. Law enforcement officials or Department of State investigators can also demand to see this card at any time to verify that you are indeed the person named on the license. There is no ambiguity in the statute regarding this requirement, and claiming ignorance or misplacing the document will not serve as a valid defense for noncompliance. You must ensure that even in the digital age, where electronic versions might be accessible, you remain familiar with the current legislative requirements regarding the display and proof of your licensure. Consistency in this area prevents regulatory investigations that could otherwise be avoided through simple diligence. See you in the next section. Welcome back. In this chapter, we explore the essential maintenance of your New York real estate license. We will examine the renewal timeline, mandate compliance for continuing education, and the legal consequences of failing to satisfy these statutory obligations. In New York, the privilege of holding a real estate license is tethered to a strict 2-year renewal cycle. Your license expiration date is specific to the date it was originally issued, and the Department of State enforces this cycle without exception. It is your professional responsibility to track this date, as relying on automated reminders is a dangerous practice that can lead to an unintended lapse in your authorization to practice. If your license expires, you are legally prohibited from performing any licensed activities, including negotiating deals or receiving commissions, until your credentials are formally reissued. The state provides a window for late renewal, but operating while expired is a violation of Article 12A that can permanently jeopardize your career. You must view this cycle not as a bureaucratic annoyance, but as a core component of your professional existence. Diligence in maintaining this timeline is the first test of your competency as a licensee in the state of New York. To maintain your active status, the Department of State requires the completion of 22.5 hours of approved continuing education every 2 years. This is not arbitrary busy work. The curriculum is designed to ensure that you remain conversant with the currents of law that govern our practice. Specifically, your hours must include mandatory modules covering fair housing, agency law, legal updates, and ethical considerations. The fair housing component is particularly non-negotiable, as the state demands that all licensees regularly reinforce their commitment to non-discriminatory practices. When you select your education providers, ensure that they are certified by the state to offer these specific credit hours. If you complete courses that do not meet these precise criteria, the Department of State will not grant you credit, effectively leaving you non-compliant despite your time and financial investment. It is vital to address the historical shift regarding exemptions, specifically regarding the grandfathering clause that once favored long-term brokers. The state has moved toward a more rigorous standard of uniformity, effectively eliminating previous exemptions that allowed experienced practitioners to bypass continuing education. Regardless of how many decades you have held a license, the requirement to complete the 22.5 hours remains absolute. The rationale is that the legal and regulatory environment in New York is fluid, and long-standing experience does not replace the necessity of keeping pace with legislative reform. This change was implemented to protect the public and ensure that every licensee, from the freshest salesperson to the most seasoned broker, operates under the same contemporary knowledge base. Ignoring this shift because of perceived seniority will result in immediate disciplinary scrutiny. When a license sits in a delinquent state, the regulatory system imposes severe consequences that escalate over time. If you fail to renew by the expiration date, you enter a lapse period where your license is technically considered inactive. While you can often regain active status by fulfilling the missing requirements and paying the necessary late fees within a specified window, the situation becomes dire if you exceed the 2-year threshold. If your license remains expired for more than 2 years, the state no longer perceives you as a temporarily delinquent practitioner, but rather as someone who has effectively forfeited their license. In this scenario, you are required to restart the entire engine of licensure, which includes sitting for and passing the state examination once again. This is a punitive, time-consuming reality that underscores the importance of simple, proactive administrative management. Throughout your renewal cycle, you are expected to maintain meticulous records of your completed course certificates. Think of your CE records as a professional audit trail, similar to the financial records you keep for tax purposes. The Department of State conducts random audits to verify compliance, and they have the authority to demand proof of your education at any time. If you cannot produce documentation verifying that you completed the required hours, you are considered non-compliant, regardless of your personal assertion that the work was done. It is a best practice to keep both physical and digital copies of every course completion certificate in a secure, redundant location. Being able to demonstrate compliance immediately upon request is a hallmark of an organized professional who understands the gravity of state oversight. See you in the next lecture. Welcome to our deep dive into the regulatory framework governing brokerage management and the oversight of licensed personnel. In this lesson, we will examine the critical responsibilities brokers bear for their teams and the structural requirements for operational legal compliance. At the heart of the broker-salesperson relationship lies the principle of vicarious liability, specifically articulated in Section 442 C of the New York Real Property Law. This legal standard dictates that a broker is held responsible for the actions of their affiliated licensees if the broker had actual knowledge of their conduct or if they retained the benefits of such conduct after being made aware of it. Effectively, you cannot claim ignorance if you have failed to implement a robust system of oversight. The Department of State interprets this as a requirement for regular, frequent, and consistent supervision. This is not a suggestion, but a codified expectation, meaning a broker who never checks in on their team or fails to review contracts is inviting severe disciplinary action. You must demonstrate that you are actively managing your office environment rather than merely collecting a split from transactions. If a salesperson commits a violation while operating under your license, the regulatory authorities look first to your supervisory process to determine the extent of your organizational culpability. To mitigate the risks associated with this liability, brokers must maintain comprehensive, written policies and procedures for office operations. This involves more than just a vague office manual. It requires detailed documentation on how property listings are handled, how advertisements are approved, and how legal disclosures must be prepared. Your record-keeping habits are heavily scrutinized, as the law expects an audit trail for every transaction from inception to closing. Everything from the training provided to new agents to the specific instructions given regarding fair housing compliance should be part of your formal office system. When regulators investigate a complaint, they do not just look at the individual agent. They ask to see the broker's manual and the evidence that these policies were actually enforced. Failing to record these procedures often leads to the assumption that no such supervision existed. Consistency is the best defense you can offer in a professional practice, as it provides a clear record of your commitment to administrative compliance. We must also be precise regarding the boundaries governing unlicensed assistants, a frequent area of confusion that leads to disciplinary proceedings. While an unlicensed person can perform clerical tasks like scheduling appointments, filing paperwork, or managing social media under your explicit guidance, they're strictly prohibited from engaging in any activity that requires a real estate license. This means they cannot negotiate the terms of a sale or a lease, nor can they discuss the price or specific provisions of a contract with a potential client. Furthermore, they are forbidden from hosting open houses where they might be tasked with answering substantive questions about the property or the market. If an unlicensed assistant is seen conducting a property tour or providing advice that constitutes brokerage activity, the broker is in direct violation of the law. You must monitor their daily activities just as closely as you monitor your licensed sales staff to ensure they are not overstepping their administrative roles. Managing branch offices requires its own specific set of regulatory hurdles that any aspiring broker must master. New York law mandates that every branch location must have its own separate branch office license, which is tied to the physical location of the business. You cannot simply operate multiple storefronts under a single main office license without following the proper registration steps and paying the associated fees. Furthermore, each branch must be under the direct supervision of either a licensed broker or an associate broker designated for that specific site. This designated person is legally tasked with the same supervisory responsibilities as the principal broker regarding the salespeople assigned to that branch. Relying on an office manager or administrative assistant to run the branch is insufficient, as the state requires a professional licensee to be accountable for the legal and ethical conduct of the branch. The broker is ultimately responsible for ensuring that this designation is active and that the supervisor is actually present and capable of overseeing the staff. Finally, we need to clarify the legal distinction between an independent contractor relationship and an employee status for the purposes of tax and management. Most real estate salespeople operate as independent contractors, which is permitted specifically under the federal tax code, provided the broker does not exercise the level of control indicative of an employer. If a broker requires a salesperson to follow a strict, hourly schedule or dictates the exact manner in which every administrative minute must be spent, they risk blurring these lines. However, Under Article 12A, a broker must provide supervision despite the independent contractor classification. This creates a nuance where you must oversee professional conduct without controlling every aspect of how the agent earns their living. You must ensure that your written agreements with your salespeople clearly outline their status to avoid unintended employment liabilities while continuing to satisfy your statutory duty to supervise them. Mastering this balance is essential for maintaining both your tax liability protections and your professional licensure status. I will see you in the next lecture. Welcome back. In this chapter, we will examine the rigid legal frameworks governing how compensation flows within the New York real estate industry. Article 12A is explicitly clear regarding the flow of money. A real estate salesperson may only receive compensation from their own sponsoring broker. This requirement serves as a structural safeguard to ensure that the broker maintains full oversight of all business activities conducted under their license. If a client attempts to hand you a commission check directly at a closing, you must politely decline and direct that payment to your sponsoring broker's business account. Similarly, receiving payment from another broker, whether for a co-broke or a referral, is strictly prohibited for a salesperson. The broker, and only the broker, is the party legally authorized to invoice or accept funds from external sources. This architecture exists to prevent off-the-books transactions that could bypass regulatory scrutiny or professional tax obligations. You represent your broker in every transaction, and your financial interactions must strictly mirror that legal dependency. If you deviate from this path, you risk not only disciplinary action from the Department of State, but also potential licensure revocation. The concept of the procuring cause is essential when discussing who is entitled to a commission, especially in the context of professional disputes. Procuring cause refers to the series of events or the chain of action that directly leads to the final sale of the property. It is not merely about who showed the house or who filed the paperwork first, but rather which licensee initiated the continuous chain of causality without abandonment. Even if you're no longer with the firm where you initiated a deal, Article 12A permits a broker to compensate you for transactions that were closed after you moved to a new firm, provided the deal began under your tenure of the previous brokerage. This recognizes the legitimate effort invested during your time there, provided your broker consents to the payout. However, compensation remains a matter of contractual agreement between you and the broker, not a guaranteed statutory right for every lead generated. Understanding this allows you to navigate transitions between offices with professional integrity while keeping your financial records clean. Navigating the landscape of referral fees requires a cautious eye toward both the Real Estate Settlement Procedures Act, or RESPA, and New York state law. The law effectively bans the payment of kickbacks or hidden referral fees to unlicensed individuals because such payments incentivize behavior that ignores client best interests. You cannot pay a neighbor or a friend for referring a buyer to you, as this constitutes a violation of the statutes governing professional licensure. In the rare instances where referral fees do occur between brokerage firms, they must be fully documented and transparently disclosed to the principals involved in the transaction. If you find yourself in a scenario where a third party suggests a kickback for a service recommendation, the safest course of action is to decline and explain the regulatory prohibition. The intent here is to preserve the integrity of the transaction, ensuring that business costs do not artificially inflate the final price paid by consumers. Reliance on finding fees for unlicensed persons is a shortcut that leads directly to regulatory noncompliance. We must also address the prohibition of net listings, which are strictly illegal under New York state real estate law. A net listing occurs when a seller stipulates a specific amount of money they wish to receive from the sale, while the broker keeps any excess proceeds as their commission. This arrangement invites a dangerous conflict of interest, as it incentivizes the broker to manipulate the sales process to maximize their own profit at the expense of the seller. For example, If a seller wants $50,000 and the broker knows the house could sell for $70,000, the broker might discourage higher offers to keep that gap as personal profit. Because the broker has a fiduciary obligation to obtain the highest possible price for the client, a net listing inherently compromises that duty. New York law mandates that commissions must be calculated based on the final sales price, not on an arbitrary net amount set aside by the seller. Avoiding this practice is not just a regulatory requirement. It is a fundamental pillar of ethical brokerage practice. Think of these financial rules as the guardrails that keep your professional reputation intact throughout your career. Every dollar you earn must be traceable back to your sponsoring broker to ensure total transparency. Adhering to these strict guidelines protects you during audits and fosters trust with your clients and colleagues. Misunderstanding these compensation laws is a common pitfall that can lead to unnecessary legal entanglements. Take a moment to review your brokerage's internal policies on commission disbursement. When you ensure that every transaction follows the legal path from client to broker to salesperson, you sustain the high standard expected of a licensed professional. Precision in your financial dealings is just as important as your skill in negotiation. Focus on clarity in your contracts to avoid ambiguity regarding how and when you are to be paid. See you in the next lecture. Welcome back. Today we begin our deep dive into the legal framework governing real estate representation in New York. We will explore the critical concepts of agency, fiduciary responsibility, and the specific ethical obligations that define your professional practice. In the world of real estate, understanding the relationship between an agent and a principal is the bedrock upon which all legal obligations are built. An agency relationship is created when a principal, often a seller or buyer, authorizes an agent to represent their interests in real estate transactions. This relationship requires a clear understanding of the difference between a client, to whom you owe fiduciary duties, and a customer, to whom you owe duties of fairness and honesty. Whether you are dealing with a general agent, such as a property manager with broad authority, or a special agent, such as a real estate broker limited to a specific transaction, the legal weight of your actions remains substantial. Universal agents, who have the power to act for a principal in all matters, are rare in our field but represent the highest level of granted authority. Agency is primarily established through an express agreement, which is a formal contract between parties, or through ratification, where a principal validates an unauthorized action after the fact. Without a proper understanding of these foundational roles, you cannot effectively navigate the complex ethical requirements set forth by Article 12A. Once an agency relationship exists, you are bound by fiduciary duties that are best remembered by the acronym OLD-SAR. Obedience requires that you follow all legal instructions provided by the principal, even if you disagree with the chosen strategy. Loyalty dictates that the principal's interests must always be placed above your own interests or those of any other party. Disclosure is the mandate to share all material facts regarding the property or the transaction that might influence the principal's decision-making process. Confidentiality ensures that sensitive information obtained during the relationship remains private, a duty that often continues even after the agency relationship has formally terminated. Accountability requires that you meticulously manage and account for all money or property entrusted to you, providing a clear record of all transactions. Finally, reasonable care mandates that you perform your duties with the competence and skill expected of a licensed professional in the New York market. Failing to uphold these standards exposes you to significant liability, as courts hold agents to a strict standard regarding the trust placed in them by their clients. One of the most consequential legal principles you must grasp is the concept of imputed notice, which essentially creates a legal tether between your knowledge and your client. If you become aware of a material fact that affects the transaction, the law presumes that your principal is also aware of that fact. This means that if you discover a hidden defect in a home but fail to inform your seller, the seller is still legally responsible for the non-disclosure because the law views your knowledge as theirs. This bridge exists because the agent is considered an extension of the principal in the eyes of the law. You must act as a reliable filter of information, ensuring that you accurately represent your principal's interests while keeping them informed of all developments. Because your knowledge is imputed to the principal, you must document your communications to protect both yourself and your client from accusations of hiding information. Understanding this link is essential for managing risk and maintaining your professional integrity throughout the listing or buying period. While our fiduciary duties are reserved for our clients, we also have significant obligations to third parties, who we classify as customers. You are legally required to treat all customers with honesty and fair dealing, ensuring that you do not engage in any form of deception. This includes the mandatory disclosure of all known material facts. You cannot hide a known leak or structural issue just because you represent the seller and want to protect their deal. Misrepresentation is a serious breach of ethics and law, categorized into three distinct types that you must learn to avoid. Active fraud involves a deliberate, intentional statement of falsehood to induce a transaction, which is rarely defensible in court. Passive fraud, or concealment, occurs when you know of a significant defect but remain silent, intentionally allowing the buyer to form a false impression. Innocent misrepresentation happens when you make a statement you believe to be true, but which is actually false, yet you're still responsible if that statement damages a party. Maintaining a standard of transparency is your best defense against claims of misrepresentation and ensures you remain in compliance with licensing laws. See you in our next lecture regarding disclosures. Welcome to this module, where we will navigate the mandatory protocols surrounding agency disclosure forms in New York real estate. Understanding these legal requirements is essential for maintaining compliance and building trust with your future clients. Section 443 of the Real Property Law is the cornerstone of consumer protection in New York real estate transactions, specifically regarding the mandatory use of the agency disclosure form. This statute requires real estate agents to provide a standardized disclosure form to potential sellers and buyers at the outset of their professional relationship. The primary objective is to make the nature of the agency relationship crystal clear, ensuring that the consumer understands who the agent represents before any confidential information is exchanged. This requirement applies specifically to residential real estate transactions, which are defined as the sale or lease of 1 to 4 unit residential dwellings, or the sale of individual condominium or cooperative units. By formalizing this relationship early, the law prevents the ambiguity that often leads to accusations of undisclosed dual agency or conflicts of interest. Consequently, failing to present this form at the appropriate moment is not merely a procedural oversight. It is a direct violation of Article 12, which can lead to disciplinary actions by the Department of State. The timing of this disclosure is governed by the concept of first substantive contact, a term that often requires careful interpretation by the practitioner. Substantive contact is defined as the first meeting or communication between an agent and a prospective buyer or seller when some form of confidential information is requested or provided. It is not necessarily the first time you speak to someone, but rather the moment the conversation shifts from general pleasantries to specific motivations, financial capabilities, or property interests. For instance, if a buyer calls to ask about the school district or the interior condition of a home, you have likely reached the threshold of substantive contact. However, if you're hosting an open house, the rules are slightly different for practical administrative reasons. In an open house scenario, you are not required to provide the disclosure form to every person who walks through the door, as an open house is generally considered a preliminary, public viewing rather than a private consultation. Nevertheless, even in an open house setting, once a visitor begins to engage in a detailed discussion about their specific financial situation, offer strategy, or private requirements, the duty to disclose arises immediately. If these conversations occur over the telephone, you must either mail or email the disclosure form to the prospective client at the earliest reasonable opportunity. It is standard practice to follow up a substantive phone call with an email containing the form, requesting that they sign and return it for your files. Do not assume that a verbal explanation of agency is sufficient, as the law explicitly requires the delivery and acknowledgement of the written document. If you do not obtain a signature, you remain in a precarious legal position, as the burden of proof regarding compliance rests entirely on your shoulders. Therefore, ensuring the document is signed and dated is the only reliable way to demonstrate that you performed your legal duty during that initial interaction. Occasionally, you will encounter a situation where a buyer or seller refuses to sign the agency disclosure form. Under New York law, this refusal does not automatically prevent you from continuing to work with the individual, but it does trigger specific record-keeping requirements. When a client or customer refuses to sign, you must prepare a written declaration that details the circumstances of the refusal. This document functions as an affidavit, noting the date, time, and location of the disclosure attempt, as well as the specific reason provided by the party for their refusal to sign. You should file this written statement with your brokerage documents, as it serves as your only defense in the event of an audit or an investigation into your conduct. Failing to document this refusal properly leaves you vulnerable to allegations that you never provided the mandatory disclosure in the first place. It is vital to distinguish between residential and commercial transactions when considering these disclosure mandates. The requirements under Section 443 strictly target residential real estate, meaning commercial transactions are entirely exempt from the specific disclosure form process. In a commercial deal, the nature of the agency relationship is typically established through a broader listing agreement or a buyer-brokerage agreement rather than this particular state-mandated form. Understanding this boundary is important because applying residential protocols to a complex commercial negotiation can be seen as an unnecessary and confusing administrative burden. However, even if you specialize in commercial work, always verify the specific nature of the property, as a residential home sold as part of a larger commercial parcel may still trigger residential disclosure mandates. When in doubt, consulting your office policy manual or broker is the best way to determine the applicable standard for a given transaction. Finally, we must address the record-keeping standards that ensure all these disclosures are held accountable over time. Once you obtain a signed copy of the disclosure form, or alternatively, the written declaration of refusal, you are legally required to maintain these records for at least 3 years. This 3-year period is the standard retention window for all core transactional documentation in New York, and it applies regardless of whether the deal successfully closes or terminates prematurely. From the moment the disclosure is signed, count your 3 years from the date of the document itself. Many agents mistakenly focus only on the closing date, but the disclosure obligation exists independently of the transaction cycle. Proper organization of these digital or physical files is the sign of a professional operation and is your first line of defense during any licensing review or legal dispute. I will catch you in the next session. Welcome back to our journey through New York real estate law. In this session, we will examine the complexities surrounding dual agency and the variations of designated agency. Dual agency occurs when a single real estate broker represents both the buyer and the seller in the same transaction. In a typical agency relationship, a broker owes undivided loyalty to their client, but this balance shifts drastically when the broker stands in the middle of two opposing interests. Because the broker is essentially representing both sides, they cannot fully advocate for the best price for the seller while simultaneously securing the lowest price for the buyer. Consequently, the fiduciary duty of loyalty is significantly narrowed, as the agent is constrained from favoring one party over the other. The law mandates that this arrangement can only exist if there is informed consent from both the buyer and the seller. This consent must be provided through a clear written acknowledgement, ensuring that all parties understand the inherent conflicts of interest involved in the process. Without this explicit, informed, and written agreement, a broker risks violating their agency obligations under Article 12A of the Real Property Law. To mitigate the risks associated with traditional dual agency, New York recognizes the concept of dual agency with designated sales agents. In this setup, the broker appoints one specific salesperson to represent the seller and a different salesperson to represent the buyer, even though both agents remain under the same brokerage umbrella. This practice is intended to restore a higher level of advocacy and provide each client with a dedicated representative who is not conflicted by the other party's goals. Even with these designated agents, the broker remains a dual agent, which means the broker must still oversee the process to ensure that each designated agent is performing their duties ethically. It serves as a structural solution to maintain the appearance and function of independent representation within a single commercial entity. By separating the agents, the brokerage attempts to minimize the direct conflict of interest while still technically operating under a dual agency framework. Regardless of the form, legal restrictions on the disclosure of confidential information remain strict and non-negotiable. When an agent is acting in a dual capacity, they are prohibited from revealing certain sensitive facts to either side without express permission. Specifically, an agent may not disclose the seller's minimum acceptable price if it is lower than the asking price, nor may they reveal the buyer's maximum budget if it is higher than their initial offer. Furthermore, the motivation of either party, such as a need to move quickly due to personal distress or divorce, must be kept strictly confidential. These protections are essential because, in a standard agency, an agent would fight for their client to gain the best financial result using these facts. In dual agency, those facts are locked behind a wall of neutrality. Failing to uphold these confidentiality standards effectively destroys the agency relationship and invites serious legal or disciplinary repercussions from the Department of State. It is also worth addressing the concept of transaction brokerage, sometimes referred to as non-agency, where the licensee acts as a facilitator rather than an agent. In some jurisdictions, this allows a broker to help both parties complete a sale without assuming fiduciary duties or the baggage of dual agency. However, New York does not formally recognize this form of transaction brokerage for residential transactions involving 1 to 4 dwelling units. In the context of New York state law, licensees are expected to act as agent for their clients with all the accompanying fiduciary responsibilities, or else they must clarify that they are not acting as an agent through the proper disclosure forms. By failing to provide a recognized, non-agency alternative for residential sales, the state maintains a rigid standard focused on consumer protection through clear agency designations. If you are not representing the buyer or the seller, you are not acting with the protections or the risks of an agent, but you must be explicit about that status to avoid accidental creation of an agency relationship. I will see you in the next one. Welcome to our exploration of the Property Condition Disclosure Statement, a critical component of transparency in New York real estate transactions. In this session, we will dissect the legal mandates imposed by the Property Condition Disclosure Act and clarify the specific obligations placed upon residential sellers. The Property Condition Disclosure Act, or PCDA, represents a shift toward mandatory transparency for sellers of residential real estate in New York. Under this legislation, sellers are required to provide a comprehensive disclosure covering the major mechanical, structural, and environmental systems of the property. The scope of this document is exhaustive, intending to surface latent defects that might not be visible during a routine walkthrough but could significantly impact the property value or the safety of the occupants. When we talk about mechanical systems, we are referring to the status of plumbing, electrical, and HVAC units, while structural concerns encompass the foundation, roof, and basement conditions. Environmental factors, meanwhile, involve issues like asbestos, radon, or lead-based paint, though these often overlap with secondary federal regulations. By forcing these elements into the light, the law aims to mitigate the classic issue of information asymmetry, where the owner knows everything and the buyer knows nothing. This framework is essential for maintaining integrity within a transaction, ensuring that neither party is blindsided by expensive repairs immediately after closing. Historically, sellers in New York had a convenient opt-out mechanism known as the $500 credit option. Many sellers preferred to simply pay this small fee rather than complete the extensive disclosure, effectively bypassing the spirit of the law for a nominal cost. Following recent legislative adjustments, this $500 credit alternative has been removed, effectively making the completion of the disclosure statement a mandatory requirement for most residential sellers. This change is not merely a bureaucratic tightening, but a meaningful recalibration of risk. When a seller chooses not to provide the statement, they're not necessarily escaping liability. Rather, they're opening the door to potential litigation if they fail to disclose known defects that a buyer subsequently discovers. As an agent, this puts you in a position where you must proactively inform your clients of their obligations under the statute. Your responsibility is to ensure the seller understands that the document is not optional and that failure to provide it may complicate the closing process or negatively affect their legal standing should a dispute arise post-closing. It is equally important to understand the specific exemptions that exist within this framework. Not every transfer of residential property requires a property condition disclosure statement. These exemptions are carefully defined, covering scenarios such as transfers between co-owners, transfers made by fiduciaries in the context of estate settlements, and transfers involving new construction where the property has not yet been inhabited. Additionally, court-ordered transfers or sales involving governmental bodies often bypass these requirements because the underlying nature of the transaction inherently deviates from a standard arm's-length market sale. Understanding these exceptions is crucial because you do not want to subject your client to unnecessary paperwork when the law specifically provides them with a safe harbor. Conversely, you must be careful not to misapply these exemptions to standard resale properties, as failing to provide the document when it is required constitutes a direct violation of regulatory expectations. Always verify the specific legal status of the transfer to determine if the PCDA mandates are triggered before advising your client on their documentation strategy. The core of the legal philosophy here is the protection of the buyer through the forced exposure of past property issues. Latent defects, such as persistent water damage in a basement or a history of significant pest infestations, are exactly the types of information the law intends to protect. If a seller is aware of these issues and fails to disclose them, they can face serious legal ramifications, including actions for damages by the buyer. By mandating this documentation, the state has effectively shifted the burden of proof toward total transparency. This ensures that a purchaser is entering the contract with their eyes open to the physical realities of the investment. From your perspective, facilitating the honest completion of this form acts as a safeguard for your professional reputation. If you are aware that a property has suffered from severe insect damage and you stand by while a seller attempts to hide that fact, you are entering dangerous ethical and legal territory. The duty is to facilitate the law, which dictates that facts about property condition must be revealed to avoid subsequent accusations of fraud or misrepresentation. I will see you in our next session. Welcome to our deep dive into the mandatory disclosures required for lead-based paint in residential real estate transactions. We will examine the federal frameworks that dictate how practitioners manage property hazards built before 1978. The Residential Lead-Based Paint Hazard Reduction Act establishes a rigorous protocol for properties constructed prior to 1978, which is the year lead was effectively banned from residential paint. As real estate professionals, our primary objective is to manage the flow of information between the seller or landlord and the prospective occupant. The law is not intended to force the removal of paint, but rather to ensure that all parties have sufficient data to make an informed decision regarding potential exposure. A key component of this mandate is the delivery of the informational pamphlet titled Protect Your Family from Lead in Your Home. You are responsible for ensuring that this document is provided to all buyers and tenants before they are contractually obligated under a purchase agreement or a lease. Failure to facilitate this exchange can result in significant legal liability, as the burden of compliance often falls on the licensee when the property owner fails to act. Beyond the simple delivery of pamphlets, the law provides a specific timeline for due diligence regarding physical inspections. When a potential buyer expresses interest in a pre-1978 property, you must allow them a 10-day period to conduct a professional lead-based paint inspection or risk assessment. Note that this time frame is negotiable, but it represents the standard window required by federal statute to ensure the consumer has adequate time to evaluate the property. If the buyer chooses to waive this right, that waiver must be documented in writing as part of the transaction file. Your role is to maintain these records, specifically the signed acknowledgement forms, for a minimum period of 3 years from the date of the transaction. This record-keeping requirement serves as an audit trail for your professional conduct in the event of a future dispute. Lead hazards are not limited to the surfaces of walls, as they often manifest in soil contamination and settled house dust as well. When paint chips or peels, the deteriorating material creates toxic dust that can easily be ingested, particularly by children in the household. It is important to distinguish between abatement and interim controls during your interactions with clients. Abatement refers to measures designed to permanently eliminate lead-based paint hazards, such as the full removal or enclosure of materials. Interim controls, by contrast, act as temporary measures aimed at reducing human exposure, such as cleaning, painting, or minor repairs to disturbed surfaces. You must understand these definitions because misrepresenting the condition of a property can lead to claims of fraud or negligence. The legal weight of failing to disclose known lead hazards is substantial and carries both civil and criminal penalties. An agent's duty extends beyond merely handing over forms. You must ensure that all parties understand the significance of the information being disclosed. If a seller is aware of lead hazards but instructs you to conceal this information, you are obligated to decline that instruction, even if it puts your relationship with the client at risk. Fiduciary duty does not override the legal requirement to comply with federal health and safety regulations. You should approach every transaction involving older homes with the assumption that potential liabilities exist, meaning that thorough and transparent documentation is your primary defense. By mastering these procedures, you protect your license and ensure the safety of the public you serve. I will see you in the next lecture. Welcome to this module on the termination of agency relationships, which is a critical aspect of your professional practice under Article 12A. We will examine the specific mechanics of how agency is dissolved and the subsequent obligations that remain. In the world of real estate, an agency relationship is rarely permanent, and understanding its conclusion is as vital as forming one. We generally distinguish between termination by the acts of the parties and termination by operation of law. Acts of the parties include scenarios where the contract reaches its natural expiration date, as specified in the listing agreement. Another common method is mutual agreement, where both the broker and the client decide to part ways, effectively nullifying the original contract. Performance also terminates the agency, most notably when the transaction successfully closes, fulfilling the purpose for which the agent was hired. Revocation by the principal is also a fundamental right, as the client can generally terminate the broker's authority at any time, though this does not necessarily absolve them of contractual damages if the termination is wrongful. When we discuss revocation, remember that while a client has the power to fire a broker, doing so in breach of a valid, time-bound listing agreement may trigger financial consequences for the client. Turning our attention to the second category, We have termination by operation of law, which functions independently of the party's intentions. A primary example is the death or incapacitation of the broker, which effectively ends the firm's legal authority to act on behalf of the client, as the license is tied to the individual or entity. In the event that either the client or the broker declares bankruptcy, the agency is terminated by law because the economic capacity to perform the contract is compromised. Furthermore, if the subject property is destroyed by a natural disaster or fire, the contract is rendered impossible to perform, thus extinguishing the agency mandate. Changes in law that make a previously legal real estate activity illegal serve as an immediate trigger for termination, as no contract can be enforced to perform an illicit act. Insanity of either party also falls into this category, as competence is a requirement for maintaining a valid agency relationship. These events are not choices made by the participants, but rather legal realities that stop the agency process instantly. It is essential to distinguish between a standard agency relationship and an agency coupled with an interest, as the latter carries significant weight regarding termination rights. An agency coupled with an interest exists when the agent has a financial stake in the property itself, beyond just the commission earned from a successful sale. Because the agent maintains this direct interest in the property, the principal does not have a unilateral right to revoke the agency at will. In standard agency, the relationship is based on personal service and fiduciary duty, which allows for broader termination flexibility by the principal. When that interest is present, the agency essentially functions as a form of security for the agent's investment, making it irrevocable by the grantor of that interest. You will find that standard listing agreements do not confer this status, so the general rules of revocation remain the default for your daily work. This distinction is often tested because it acts as an exception to the standard power of clients to terminate their brokers. Even after the formal relationship has ended, your professional obligations do not vanish into thin air. One of the most persistent duties under the umbrella of fiduciary care is the ongoing duty of confidentiality regarding the client's private information. You are legally prohibited from disclosing confidential facts, such as the client's motivation for selling, their financial thresholds, or other personal details, even years after the deal has failed or closed. This duty survives the expiration of the listing agreement because of the trust inherent in the agency relationship, and failing to uphold this is a breach of your ethical and legal license requirements. When a contract is terminated, it is good practice to formalize the end of the relationship with written communication to avoid ambiguity regarding when your fiduciary duties toward that specific client ceased. If you are ever involved in a situation where a client attempts to withdraw from an agreement early, prioritize documenting the status of your services to minimize potential exposure to claims of abandonment or breach of contract. Wrongful termination is a serious matter that can lead to litigation between the broker and the client, specifically regarding the recovery of losses incurred during the term of the agency. If a principal terminates a broker prematurely without cause, and that broker has expended significant time or money on marketing or showings, the broker may sue for damages related to breach of contract. Conversely, if a broker abandons a client without a legal basis, the broker could face discipline by the Department of State for failing to perform their duties under Article 12A. Always look to the specific language of your listing agreements, as these documents define the boundaries of potential damages if one party reneges on their promise. Maintaining a clear understanding of the difference between an agency that has been rightfully concluded and one that has been wrongfully terminated will protect your license and your business reputation throughout your career. You are managing a professional relationship, and the legal framework provides structure for how that relationship should start, evolve, and ultimately end. See you in the next module. Welcome to our discussion on Federal Fair Housing Act compliance, where we establish the firm boundaries of legal conduct in real estate transactions. Understanding the evolution of fair housing laws starts with the Civil Rights Act of 1866, which remains a cornerstone of property rights in the United States. This legislation provides that all citizens have the same rights as white citizens to inherit, purchase, lease, sell, hold, and convey real and personal property. Importantly, the courts have interpreted this as an absolute prohibition against racial discrimination. Unlike later statutes, the 1866 Act has no exemptions, meaning that if discrimination based on race occurs, there is no defense available to the practitioner. It is an absolute mandate that guides every interaction between a licensee and a prospective buyer or tenant. When you are representing a client, your obligation to adhere to these principles is not merely a suggestion, but an immutable legal requirement. Ignoring this foundation is the quickest path to losing your license and incurring severe federal penalties. The Fair Housing Act of 1968, appearing as Title VIII of the Civil Rights Act, significantly expanded these protections to cover broader categories of discrimination. Over time, Congress added several protected classes, which now include race, color, religion, national origin, sex, familial status, and disability. The practical application of this law prohibits any refusal to sell, rent, or negotiate based on these protected characteristics. Furthermore, it outlaws discriminatory advertising that indicates a preference or limitation, as well as the practice of blockbusting. Blockbusting, often referred to as panic peddling, involves inducing homeowners to sell their property by making representations regarding the entry of minority groups into the neighborhood. Such tactics are predatory and fundamentally contrary to the professional standards required in our industry. By maintaining objective perspective, we ensure our actions remain in strict alignment with federal mandates. Beyond overt discrimination, we must address subtle or structural barriers like steering and redlining. Steering occurs when a licensee directs prospective buyers or renters toward or away from certain neighborhoods based on their membership in a protected class. Redlining involves lenders denying services or increasing the cost of services, such as mortgage insurance or loans, for individuals in specific geographic areas based on the demographics of the population. Both practices are violations of the law because they limit the choices of consumers based on protected status rather than financial qualifications. You must always present opportunities to clients based solely on their express preferences and economic realities. To do otherwise is to engage in a policy of disparate impact, where a seemingly neutral practice, such as a rigid neighborhood preference survey, inadvertently leads to discriminatory outcomes. Recognizing that these practices are illegal allows you to provide fair and equitable service to everyone. Accommodating persons with disabilities requires a specific understanding of reasonable modifications and reasonable accommodations. A reasonable modification is a structural change made to the premises, such as widening a doorway or installing a ramp, which the tenant is generally allowed to perform at their own expense. A reasonable accommodation refers to a change in rules, policies, or practices, such as allowing a service animal in a building that otherwise enforces a no-pet policy. The Department of Housing and Urban Development, or HUD, provides the enforcement mechanism for these regulations, investigating complaints and imposing sanctions. The 1988 Amendments Act further strengthened the law by enhancing penalty structures and explicitly adding familial status and disability to the protected classes. These laws are designed to remove barriers to housing equality for all individuals regardless of their physical capabilities or family structure. Compliance with these requirements should be handled with professional care and consistency to avoid any risk of litigation. I look forward to discussing how these principles apply in our next segment. Welcome to the chapter on New York State human rights, where we will examine the stringent protections that govern real estate practices beyond federal mandates. We will discuss specific protected classes and enforcement mechanisms that every licensee must understand to maintain compliance. The New York State Human Rights Law, found under Article 15 of the Executive Law, provides significantly broader protections than its federal counterpart. While federal law focuses on 7 protected classes, the state law expands this list to include age, marital status, sexual orientation, gender identity or expression, military status, and source of income. This means a real estate professional cannot deny housing or refuse to negotiate based on whether an applicant is 18 years of age or older, or whether they are single, married, or divorced. Furthermore, you cannot discriminate against someone based on their military status or the fact that they pay their rent through legitimate sources like Section 8 vouchers or other government subsidies. The inclusion of source of income is a critical distinction that frequently trips up agents who assume that federal standards represent the entirety of their legal obligations. Mastering this list is not merely an academic exercise, it is the foundation of your ethical and legal professional practice in this state. If you find yourself evaluating a client based on these criteria, you are already operating outside the boundaries of the law. One of the most consequential aspects of a New York State human rights law is its near-universal application to housing accommodations, regardless of the size of the property. Unlike federal guidelines, which provide specific exemptions for owner-occupied dwellings under certain circumstances, state law is far more restrictive. While you may have heard of the federal Mrs. Murphy exemption, which allows owners of small, owner-occupied dwellings to exclude certain groups, its application in New York is severely limited. Under state law, the exemption for an owner-occupied two-family house is notably narrower than what federal statutes might suggest, and in many rental scenarios, it effectively disappears. You should always default to the assumption that every housing transaction you facilitate is subject to these anti-discrimination rules. Attempting to apply federal exemptions to a state-level transaction is a common path toward liability and professional misconduct. Reliability in your practice requires recognizing that the local jurisdiction demands a higher standard of inclusivity than what you might see in a national textbook. Enforcement of these regulations falls under the purview of the New York State Division of Human Rights, which possesses the authority to conduct comprehensive investigations into any alleged discriminatory acts. If a complaint is filed, the division acts as the primary administrative body to determine if probable cause exists, often leading to formal hearings. The penalties for failing to adhere to these standards are severe and have direct consequences for your career and livelihood. Violators may be ordered to pay significant compensatory damages to the aggrieved party, face hefty civil fines, and undergo mandatory training. Perhaps most critically, the Secretary of State maintains the authority to revoke or suspend your real estate license following a finding of discrimination. When your license is the vehicle for your income, the risk of violating these statutes should be viewed as an existential threat to your business. This is why strict adherence is not just a moral imperative, but a fundamental requirement for risk management in the real estate industry. See you in the next lesson. Welcome back. In this lesson, we will examine the specific mandates of the New York City Administrative Code regarding fair housing and how they enhance existing standards. When we discuss fair housing in New York City, we are operating within a legal framework that frequently exceeds the baseline protections established by federal and state law. The New York City Human Rights Law is codified within the Administrative Code and is specifically designed to provide broader coverage for residents of the 5 boroughs. While you're likely familiar with protected classes such as race, color, and religion, the city adds unique categories that a real estate professional must identify immediately. These include citizenship status, which prohibits discrimination based on whether a person is a citizen or a national, and partnership status, which protects individuals based on their domestic partnership or marital status. We must also consider the category of lawful occupation, which prevents landlords or agents from refusing to lease to individuals based on their specific profession. These protections are absolute, and as a licensee, you are expected to navigate these requirements without exception, as the city imposes a higher standard of scrutiny than you might encounter in other jurisdictions. A significant component of the New York City Administrative Code involves the source of income law, which fundamentally shifts how agents interact with prospective tenants utilizing housing subsidies. Under this provision, it is illegal for a landlord or a real estate agent to refuse to rent to a person solely because they rely on government assistance, such as Section 8 vouchers or other public housing subsidies. You cannot implement policies that effectively exclude these individuals, nor can you steer them toward specific units while denying access to others based on the payment method. If a subsidy covers the rent, the legal obligation to consider the applicant is exactly the same as if the applicant were paying from a private salary. This law is strictly enforced to prevent discriminatory practices that historically concentrated voucher holders in specific, often substandard, housing sectors. Failure to comply with these rules does not merely result in a minor administrative reprimand. It invites direct intervention and enforcement from city authorities. We must also address the Fair Chance for Housing Act and how it governs inquiries into the criminal history of an applicant. The New York City Administrative Code restricts the ability of housing providers to conduct background checks during the initial stages of the application process. Generally, you cannot inquire about criminal history or perform a background check until a conditional offer of housing has been extended to the applicant. The intent here is to evaluate the financial capability and suitability of the tenant before their criminal record can prejudice the decision. If you do conduct a check after the offer, you must provide the applicant with a notice regarding their rights, including the ability to provide evidence of rehabilitation or extenuating circumstances. Navigating this regulation requires a careful, methodical approach to the application process where you isolate financial screening from character evaluation. Any deviation from this sequence puts your license and your client's legal standing in immediate jeopardy. Investigations regarding these protections are handled by the New York City Commission on Human Rights, which possesses robust authority to pursue complaints. When a violation is suspected, the Commission can launch an investigation, subpoena records, and hold hearings to determine if discriminatory conduct occurred. If they find that a violation has taken place, the penalties are designed to be punitive and remedial rather than merely nominal. Landlords and agents can be ordered to pay substantial civil penalties, which are paid to the city, as well as compensatory damages for the victims of the discrimination. Beyond these financial burdens, the Commission frequently mandates that the involved parties participate in comprehensive fair housing training to ensure future compliance. This effectively means that your professional reputation and your capacity to conduct business are tied directly to your adherence to these expansive local standards. When you encounter a conflict between federal, state, and city laws, the cardinal rule is to always yield to the most restrictive standard. You are effectively acting as an extension of the law when you manage or list property within the city limits, and you cannot opt for a lower threshold simply because it appears in a state or federal statute. If the state allows for a practice that the city explicitly forbids, you must follow the city's prohibition to ensure maximum protection for the consumer. This requires you to stay informed on the local administrative landscape, as amendments to the code occur more frequently than sweeping changes at the federal level. Your responsibility is to shield your clients from the liability of noncompliance while ensuring that your conduct remains beyond reproach. Treat the local code as the primary set of rules for any transaction occurring within the 5 boroughs, and you will align your practice with the rigorous expectations of the Commission on Human Rights. See you in the next lecture. Welcome back. Today we examine the specific prohibitions against steering and blockbusting, 2 practices that fundamentally undermine fair housing principles and carry significant legal consequences for licensees. Steering is defined as the practice of directing prospective buyers or tenants toward or away from certain neighborhoods, locations, or buildings based on their membership in a protected class. A licensee might engage in this by assuming a client prefers to live near people of their own background, which is a harmful bias that violates both federal and state mandates. Even if the licensee believes they are being helpful, the act of limiting someone's housing options based on race, color, religion, gender, or national origin is strictly illegal. The core of this prohibition is that every individual must be afforded the same opportunity to choose where they want to live, regardless of whether a real estate agent agrees with that choice. To avoid steering, do not offer unsolicited opinions about the demographic composition of an area or suggest that a client would be more comfortable elsewhere. Instead, focus entirely on the physical characteristics of the property and the client's stated requirements. Providing a client with comprehensive information about every available property that meets their objective criteria is the only way to ensure compliance with the law. By removing protected characteristics from your decision-making process, you protect yourself and your professional reputation. Blockbusting, which is sometimes referred to as panic selling, is the illegal act of inducing homeowners to sell their properties by suggesting that the entry of a protected class into the neighborhood will negatively impact property values or social stability. This practice creates artificial fear and promotes segregation, which is why New York laws prohibit any solicitation that leverages these fear-based tactics. A licensee might tell a seller that they need to list their home immediately because people of a certain race or religion are moving onto the block and that property values are about to plummet. This is a clear-cut violation of a New York State human rights law and federal statutes. Such behavior is not merely unethical. It is a serious professional liability that can result in the immediate loss of a real estate license and substantial legal penalties. Real estate professionals have an obligation to provide objective market data rather than engaging in fear-mongering to secure listings. Your job is to facilitate transactions, not to manipulate the social or economic composition of a neighborhood through deceptive and discriminatory rhetoric. One of the most frequent challenges in this area is knowing how to respond when a client asks, "How is this neighborhood?" If you answer based on the demographics or the perceived cultural shift of the area, you're walking directly into a potential fair housing violation. A safe and professional way to handle this is to provide strictly objective, property-specific information rather than commentary on the residents. You might discuss the proximity to public transportation, the quality of local schools, or the age and architectural style of the homes, provided those facts are verifiable and consistently shared with all clients. If a client insists on asking about the demographic makeup of a specific area, simply explain that your professional focus is on the property itself and the market statistics. This neutrality prevents the perception of steering and maintains your professional boundaries. Remember that your duty is to assist with a real estate transaction, not to act as a consultant on demographic trends. By sticking to these facts, you avoid the subjective trap that leads to accusations of discrimination. Testing programs are utilized to uncover discriminatory behavior by sending individuals, known as testers, to inquire about real estate services while posing as typical clients. These testers are trained to document every interaction, from the quality of service provided to the specific information offered regarding properties and neighborhoods. If a licensee provides different options or treats a tester differently based on their perceived protected status, those findings serve as powerful evidence in court. The legal weight of these findings is significant because they frequently lead to administrative hearings and civil rights lawsuits. It is important to treat every client with identical attention and provide them with the same level of support, without regard to their appearance, background, or identity. Because testers do not disclose their identity until after the interaction, you must act in full compliance with fair housing laws during every single appointment. Maintaining a high standard of professional service for everyone is not just a legal requirement, but a fundamental aspect of operating as a competent licensee. In certain parts of New York, the Secretary of State has the authority to declare cease and desist zones to prevent aggressive solicitation that contributes to blockbusting. Within these designated areas, homeowners can file a request to be placed on a list that prohibits real estate licensees from soliciting their business. Once a homeowner is on this list, it is illegal for a licensee to contact them for the purpose of obtaining a listing, even for general advertising purposes. This enforcement tool is intended to stabilize communities that are being subjected to excessive pressure to sell their homes. As a professional, you are responsible for checking whether a property falls within a designated cease and desist zone before you begin any solicitation efforts. Failure to honor these requests can lead to significant fines and disciplinary action against the licensee or the brokerage. Staying informed about these local regulations ensures that your marketing efforts remain both effective and lawful. See you in the next lecture. Welcome to this focused exploration of advertising guidelines and inclusive language within the framework of New York real estate practice. We will now examine how to translate regulatory requirements into compliant marketing materials that avoid legal pitfalls. When we approach the topic of real estate advertising in New York, we must move beyond the common misconception that creative writing is a license to say whatever sells a property. Under Regulation 175.25, the primary directive is the absolute prohibition of what we call blind ads. A blind ad is any advertisement that fails to provide the licensed broker's corporate name and a clear method for consumers to contact that office. Even if you're a highly successful salesperson working under a broker, you cannot simply put your own name and phone number on a sign or an online listing. The regulatory intent here is transparency. The public needs to know exactly which entity holds the license and bears the ultimate responsibility for the transaction. If a property listing appears on a website or a physical flyer without the broker's full business name, you are effectively operating in a gray area that the Department of State views as deceptive. Every piece of marketing collateral, whether it is a glossy brochure, a digital social media post, or a lawn sign, must link the property back to the responsible brokerage. Failure to include this information is not just a minor clerical error. It is a violation that can trigger disciplinary action. Always ensure your brokerage's branding is prominent enough that a reasonable consumer can identify the party they're dealing with at a glance. The intersection of advertising and fair housing law is perhaps where professionals most frequently encounter unintended liability. Creating marketing copy requires a delicate balance between highlighting a property's features and inadvertently expressing a discriminatory preference. Using phrases like perfect for singles or proximity to specific houses of worship can be interpreted as steering or exclusionary language. When you characterize a property in a way that suggests it is only suitable for a specific demographic, you are walking into a violation of both state and federal law. Even well-intentioned descriptions regarding the character of a neighborhood must avoid any language that could reasonably be read as discouraging protected classes from inquiring about the property. The test is not your intent as the writer, but the perception of the ordinary reader. If your copy suggests that certain groups are preferred or excluded, you have likely crossed the line into prohibited conduct. This is not about stifling marketing efforts, but rather ensuring that housing opportunities are open to everyone on an equal basis. Professional conduct requires a rigorous review of every adjective and noun to ensure they describe the physical property rather than the people who should live there. Beyond the text itself, the physical presentation of your advertisements plays a critical role in demonstrating compliance. You have likely seen the Equal Housing Opportunity logo and the corresponding slogan. These are not merely decorative elements, but essential signals of your adherence to the law. In digital marketing and social media campaigns, these symbols should be easily accessible, often linked to the brokerage website's fair housing policies. When you utilize digital platforms, the rules do not change simply because the medium is dynamic or interactive. Every post on a platform like Instagram or Facebook must satisfy the same disclosure requirements that apply to traditional print media. If you share a property listing in a format that truncates the content, you must design it so that the broker's identification is readily visible. Signage rules are similarly stringent, requiring that broker identification be clearly legible from a reasonable distance. You are responsible for every digital footprint your business leaves behind, and the Department of State treats online advertisements with the same scrutiny as printed advertisements in newspapers or magazines. A common point of contention is the distinction between puffing and outright misrepresentation during the listing process. Puffing is generally defined as an obvious exaggeration or expression of opinion that a reasonable person would not take as a factual representation of the property's condition. For example, calling a small room cozy or a house a once-in-a-lifetime opportunity is typically accepted as creative marketing. However, when you pivot to making factual claims about square footage, structural integrity, or the operability of systems, you have left the realm of puffing and entered the territory of potential misrepresentation. Providing false or misleading information to induce a client to pursue a property is a clear path to both administrative sanctions and potential civil litigation. As a licensee, the burden of truth rests on your shoulders, and you must verify that any claims made in an advertisement are substantiated by factual data. If you are ever in doubt as to whether a statement is puffery or a misrepresentation, the safest course of action is to stick to the observable, provable facts of the property. Precision in your professional vocabulary acts as a vital safeguard against the risks of misleading the public. Finally, we must acknowledge the specific requirement for license disclosure by individual salespeople. While the broker assumes responsibility for the brokerage, you as a licensee have an individual obligation to disclose your status in certain marketing contexts. The law is designed to prevent consumers from being deceived about who they are interacting with, ensuring they understand the nature of the professional helping them. When you're representing yourself in a transaction or conducting business, honesty about your status as a licensee is non-negotiable. Misleading the public about your role or identity in an advertisement is a direct violation of the standards set forth under Article 12A and its associated regulations. You must always maintain a clear distinction between your identity as a licensee and any potential side interests you might have. Through disciplined adherence to these advertising standards, you protect your professional reputation and contribute to a more transparent real estate market. See you in the next lecture. Welcome back to the course. In this lesson, we will examine the legal nuances of reasonable accommodations and service animals within the context of housing law. When we approach the topic of reasonable accommodations, it is useful to maintain a clear distinction between policy changes and physical alterations. A reasonable accommodation refers to a change in rules, policies, practices, or services that is necessary to afford a person with a disability an equal opportunity to use and enjoy a dwelling. For example, if a building has a strict no-smoking policy, granting an exception for a tenant who requires the use of certain medical devices that involve smoke extraction would be a policy accommodation. Conversely, a reasonable modification involves physical changes to the premises, such as widening doorways or installing grab bars in a bathroom. Under federal and New York state law, landlords generally cannot refuse a reasonable request for these modifications. The distinction is critical because, while the landlord must allow the modification, the financial obligation to pay for the installation and the subsequent restoration of the property usually falls upon the tenant. You must avoid conflating these two concepts, as the legal pathway for approval can differ significantly depending on whether the request impacts property structure or administrative protocol. Service animals and emotional support animals occupy a unique space in housing regulations, often serving as a point of friction for property managers who are unfamiliar with fair housing requirements. The Americans with Disabilities Act primarily governs service animals in public accommodations, but the Fair Housing Act provides a broader umbrella concerning emotional support animals within private residential dwellings. It is a fundamental error to treat these animals as pets under a lease agreement. Consequently, Any attempt to impose a pet deposit, a monthly pet rent, or a weight limit restriction on a verifiable assistance animal constitutes a violation of fair housing principles. You are essentially dealing with an auxiliary aid, not a domesticated pet, and your professional conduct must reflect this distinction in every interaction with clients. If a landlord insists on applying a standard pet policy to an animal that provides disability-related assistance, you are obligated to correct that misunderstanding to prevent potential litigation. The focus must always remain on whether the tenant has a disability-related need for the animal, rather than the specific species or training of the animal itself. Navigating the verification process for these requests requires a delicate balance between due diligence and the strict privacy rights of the requester. When a person requests a reasonable accommodation, the landlord is permitted to ask for documentation only if the disability or the need for the accommodation is not readily apparent. In instances where the disability is obvious and the connection to the accommodation is logical, such as a wheelchair user requesting a ramp, further verification is unnecessary and arguably invasive. If the need is not obvious, however, you may request information from a medical professional, social worker, or peer support group that clarifies the nexus between the disability and the requested adjustment. You must never inquire about the specific nature, severity, or diagnosis of the disability, as this data is protected by privacy statutes. The goal is to establish functionality, not to uncover medical history. Maintaining this professional boundary protects both the landlord from liability and the tenant from discriminatory intrusion. New York State law imposes specific requirements regarding what is often called a notice of rights for reasonable accommodations. This mandate ensures that tenants and prospective tenants are informed of their rights proactively rather than only discovering them during a dispute. As a licensee, you should be prepared to facilitate the distribution of such notifications whenever a client expresses a need for an adjustment. Furthermore, we must acknowledge the difference between public accommodations and private dwellings regarding the removal of physical barriers. While commercial spaces are subject to stricter mandates regarding immediate barrier removal to ensure accessibility, private rental units rely more heavily on the reactive framework of individual requests for modification. If you are handling a transaction involving a commercial storefront, the accessibility standards under the Americans with Disabilities Act are considerably more rigid than they are for a standard apartment unit. Understanding this bifurcation helps you accurately advise property owners on their capital expenditure responsibilities and their long-term compliance exposure. See you in the next lecture. Hello, and welcome back to our deep dive into the regulatory framework of New York real estate. Today, we are turning our attention to rent stabilization and control laws, a critical subject that often appears on the state examination. In New York, distinguishing between rent control and rent stabilization is fundamental to understanding your obligations as a licensee. Rent control serves as the older, more restrictive system, primarily applying to buildings constructed before 1947, where the tenant has been in continuous occupancy since July 1, 1971. In contrast, rent stabilization generally covers buildings with 6 or more units constructed between 1947 and 1974, though some newer buildings may be included due to tax incentive programs. Understanding these technicalities helps you guide landlords and prospective tenants through the legal realities of lease renewals and rent adjustments. If you misunderstand the jurisdictional boundaries established by the Emergency Tenant Protection Act, or EPA, you expose yourself and your clients to a significant degree of professional liability. Precise knowledge of these legacy laws is not optional in the current regulatory environment. The landscape of housing law underwent a seismic shift with the passage of the Housing Stability and Tenant Protection Act of 2019, commonly referred to as the HSTPA. This legislation effectively ended several mechanisms that previously allowed landlords to remove units from the regulated market. Specifically, The HSDPA repealed the practice of luxury decontrol, which once enabled owners to deregulate high-rent apartments once they reached a specific threshold. Furthermore, the vacancy bonus, which historically allowed owners to increase rent percentage-wise upon the turnover of an apartment, has been eliminated entirely. These changes imply that the economic model for owners, particularly those who rely on unit turnover to recover costs, has been fundamentally constrained. You must understand that these regulations are administered by the New York State Homes and Community Renewal Agency, the body responsible for oversight and enforcement. When we discuss the maintenance of regulated apartments, we must address the specific limitations placed on capital expenditures known as major capital improvements and individual apartment improvements. Historically, landlords utilized these improvements to justify permanent rent increases, but the 2019 reforms drastically limited the amount that can be recouped through rent hikes and established strict expiration periods for these adjustments. For example, the total cost of individual apartment improvements is now amortized over a much longer period, and there are strict annual caps on how much the rent can be raised based on these investments. Additionally, the statute now strictly limits security deposits to a maximum of 1 month's rent, regardless of the tenant's credit history or financial profile. If you attempt to negotiate a lease that includes a 2-month security deposit in a regulated unit, you are effectively asking for an unenforceable term. Succession rights represent another area where the regulations provide specific protections for household members residing with a primary tenant. If a tenant passes away or permanently vacates, a family member who has resided in the apartment as their primary residence for at least 2 years may be entitled to succeed to the tenancy under certain conditions. This period is reduced to 1 year for individuals who are at least 62 years of age or disabled. Because these rights frequently result in litigation, understanding who qualifies as a family member under the law is essential for anyone involved in property management. You're not meant to provide legal advice in these instances, but you are expected to know that these protections exist as a matter of law. Silence or misinformation regarding these rights can lead to severe consequences for your clients. As you can see, these rules function as a rigid set of constraints on the landlord-tenant relationship throughout the state. The New York State Homes and Community Renewal Agency acts as the central authority for filing complaints, registering rents, and interpreting these complex statutes. As a licensee, your role is to navigate these constraints without inadvertently encouraging noncompliance or facilitating illegal lease terms. Because these laws are dense and prone to frequent administrative updates, prioritizing the current statutes over outdated industry practices is paramount. Ensuring that you are advising your clients according to the 2019 standards, as opposed to practices that were common decades ago, will distinguish you as a competent professional. Maintaining this focus is the only way to ensure the long-term viability of your professional reputation in a highly regulated market. I will see you in the next lecture. Welcome to our exploration of federal and state antitrust regulations, where we will examine how market competition is strictly protected within the real estate industry. We will focus on identifying prohibited practices that artificially restrain trade and the severe legal consequences that follow such violations. The Sherman Antitrust Act serves as the backbone of competition law in the United States, and its principles are rigorously applied to the real estate sector to ensure a fair marketplace. At its core, this legislation prohibits any contract, combination, or conspiracy that unreasonably restrains trade, effectively mandating that firms must compete independently. In the context of New York real estate, this means that brokers must never engage in price fixing, which occurs when competing firms communicate to establish standard commission rates. Even an informal conversation at a local Chamber of Commerce dinner regarding the typical fee a broker charges can be construed as an illegal agreement. Since commissions are supposed to be fully negotiable between a client and their agent, Any attempt to standardize them across the industry eliminates the consumer's ability to shop for competitive pricing. Brokers are encouraged to maintain strictly internal policies that prohibit discussing commissions with individuals outside of their own specific brokerage. Group boycotting represents another significant violation where real estate professionals conspire to refuse to deal with a particular competitor or service provider. This often manifests when a group of established brokerages agrees to stop participating in listings or referrals involving a discount firm that threatens their market share. By excluding these companies from a multiple listing service or social professional networks, the conspirators exert an unfair advantage that prevents the marketplace from functioning naturally. Market allocation is a similarly destructive practice, where competing firms decide to carve up neighborhoods or property types to avoid direct competition. If two local brokerages agree that one will only handle listings north of a specific avenue while the other takes the south, they are effectively granting each other an illegal monopoly in those designated territories. These practices are easily identified by regulators, yet they remain a primary focus for antitrust enforcement because they directly harm the public by limiting choice and innovation. Tie-in arrangements create another layer of scrutiny, occurring when a broker conditions the delivery of one essential service upon the client's agreement to purchase another, often unrelated, service from a specific provider. For instance, if a brokerage refuses to represent a buyer unless that buyer also utilizes their in-house mortgage division or a specific title insurance company, they have established an illegal tie-in. Such arrangements prevent consumers from evaluating the quality and cost of ancillary services independently, which is a fundamental right in real estate transactions. The regulatory bodies governing New York real estate take these violations extremely seriously, and the consequences for noncompliance are intentionally severe to deter such behavior. Courts have the authority to impose treble damages, which means that any party harmed by an antitrust violation can recover 3 times the actual amount of damages they suffered. When you add federal fines that can reach millions of dollars and the potential for federal prison sentences, the risks far outweigh any short-term gain derived from restricted competition. Professional, legitimate practice in this industry requires an absolute commitment to independence and transparency in every business interaction. Your office policy should emphasize that all commission structures are proprietary and that your firm does not coordinate pricing, territories, or vendor relationships with any other competing agency. By adhering to these standards, you protect both your reputation and your professional license from the life-altering consequences of antitrust litigation. See you in the next lecture. Welcome back. In this lecture, we're going to explore the strict regulatory landscape governing how real estate brokers must manage client funds under Article 12A. Section 175.1 of the New York Real Property Law is uncompromising when it comes to the handling of funds belonging to others. When a client hands over a down payment or earnest money, the broker acts not as an owner, but as a fiduciary trustee. The most fundamental rule here is the prohibition of commingling, which is defined as the mixing of client funds with the broker's personal or business operating accounts. Even if the broker fully intends to return that money later, the simple act of placing it into an account used for office expenses or personal purchases is a severe violation. In the eyes of the Department of State, commingling is one of the leading causes of license revocation. Professional integrity relies on the complete separation of fiduciary duties from the broker's individual financial life, and the law enforces this with strict disciplinary measures. To ensure this separation, a broker is required to maintain one or more separate, non-interest-bearing escrow accounts, specifically designated for trust funds. While interest-bearing accounts are technically possible if the client and all other parties agree to it in writing, the standard practice remains the non-interest escrow account. Once a broker receives a deposit, they must adhere to a strict timeline for placing those funds into the designated account. Generally, these funds must be deposited within a reasonable period, which in the context of these regulations means immediately or is specified by the contract, but never delayed to the point of risk. Failing to move the money promptly exposes the broker to accusations of conversion, which occurs when a broker uses funds belonging to a client for any purpose other than what was legally directed. Conversion is essentially the unauthorized application of trust funds, and it poses an existential threat to your career. Unlike commingling, which involves the improper placement of funds, conversion involves the actual expenditure or misdirection of those funds. The record-keeping requirements for these accounts are equally rigorous because every single dollar must be accounted for from the moment it enters the account until it is disbursed. You are required to maintain detailed logs of all deposits and withdrawals, documenting the source of the money, the purpose of the transaction, and the identity of the person for whom the funds are being held. If a regulator arrives for an audit, you must be able to produce a clear, chronological trail that matches your bank statements perfectly, as any discrepancy is treated as professional negligence. Legal disputes frequently emerge regarding the disbursement of these funds, especially if a real estate deal fails at the last minute. In such scenarios, the broker might find themselves caught between a buyer demanding a refund and a seller claiming the deposit as liquidated damages for breach of contract. Regardless of how heated these disputes become, the broker must never unilaterally decide who is entitled to the money. The funds must remain securely in the escrow account until the broker receives a written, signed agreement from all parties directing the disbursement or until a court order dictates the outcome. Departing from this path by releasing funds prematurely is almost a guaranteed way to lose your license, as the broker does not have the legal authority to adjudicate the outcome of a contract. It is important to note the operational distinction between downstate and upstate transactions regarding who holds this deposit. In New York City and the surrounding downstate area, it is customary for the seller's attorney, rather than the broker, to act as the escrow agent and hold the contract deposit. This practice naturally offers a layer of protection to the broker, as it removes the risk of mishandling funds that were never in their possession. However, in many upstate transactions, the broker often holds the deposit directly, which places the full weight of these Section 175.1 responsibilities squarely on their shoulders. Understanding your local market practice is vital, but always remember that the legal standards for the fiduciary care of money remain high in both scenarios. I will see you in the next lecture. Welcome back. And today we are focusing on the precise legal frameworks governing property management and the specific statutory requirements that define the landlord-tenant relationship in New York. When we approach property management under New York law, the primary rule is that if you're performing real estate activities for a third party for a fee, you're acting as a real estate broker. This necessitates a valid real estate broker's license, as the management of property essentially constitutes real estate activity under Article 12A. You cannot manage property for compensation without this licensure, even if you are not the primary owner. When you handle security deposits, the law is rigid regarding the sanctity of those funds. You must deposit tenant security in an interest-bearing account and provide the tenant with written notification containing the name and address of the banking institution where that money is held. Failure to keep these funds in a separate account is considered commingling, which is a severe violation of licensing law. The concept of the warranty of habitability serves as the backbone of residential leasing in New York, stipulating that every residential lease contains an implied promise that the unit is fit for human habitation. This is a non-waivable statutory requirement that holds the landlord responsible for maintaining essential services and ensuring the structure is free of conditions that could be dangerous to life, health, or safety. Closely related to these safety standards are the mandates regarding life safety equipment, including the installation and maintenance of smoke alarms and carbon monoxide detectors in every residential dwelling unit. Property managers must verify that these devices are present and functional at the commencement of a tenancy. These requirements are not merely suggestions. They are regulatory obligations that, if neglected, lead to significant legal liability. Often, property managers are called upon to handle difficult tenant situations, but they must strictly adhere to legal eviction procedures. New York law explicitly prohibits self-help evictions, which means a landlord or manager cannot forcibly remove a tenant, change the locks, or remove their belongings without a court order. Any attempt to bypass the judicial system through intimidation or physical removal of a tenant from their residence is an illegal act that subjects the manager to severe penalties. The only path to legal possession of a unit after a lease violation or expiration is through a summary proceeding held in housing court. This involves serving proper notices and obtaining a warrant of eviction, which must be executed by a sheriff or marshal. The Housing Stability and Tenant Protection Act of 2019 brought sweeping changes that every property manager must integrate into their daily operations. Specifically, this law overhauled application processes by capping application fees at a maximum of $20, and it mandates that if a tenant provides their own background or credit check report from a consumer reporting agency, the manager cannot charge an application fee. Furthermore, the Act significantly restricted the collection of late fees, capping them at $50 or 5% of the monthly rent, whichever is less, and strictly prohibited late fees until a rent payment is more than 5 days late. These provisions were designed to standardize and professionalize the leasing process, and as a professional, you are expected to apply these caps without exception. Finally, we must address the critical environmental obligations regarding lead paint and mold. For properties built before 1978, managers are mandated to provide the lead-based paint disclosure and a specific informational pamphlet, as lead-based paint contamination poses a major health risk to residents, particularly children. In addition to these statutory rules, recent legislative trends emphasize transparency in mold remediation, requiring managers to ensure that mold issues are inspected and remediated by professionals to comply with habitability standards. Ignoring these environmental mandates does not merely create a civil dispute. It often triggers investigations by state and local enforcement agencies. Professional management requires a systematic approach to these regulatory burdens to ensure compliance is maintained throughout the life of the tenancy. See you in the next lesson. Welcome to our analysis of the independent contractor relationship, where we define the legal boundary between a real estate broker and their associated salespeople. In the professional life of a real estate agent in New York, the distinction between an employee and an independent contractor is fundamental, primarily because it dictates how you are taxed and how you operate within a brokerage. Under the Internal Revenue Service Guidelines and New York Labor Law Section 511, the primary factor determining this status is the degree of control the broker exerts over the salesperson. When a relationship is structured as that of an independent contractor, the salesperson effectively operates as their own business entity. This means you are responsible for paying your own self-employment taxes, setting your schedule, and covering your own business expenses without the benefit of employer-provided tax withholding. The legal frameworks are designed to ensure that those who function with autonomy are treated as such, protecting the broker from being forced to provide benefits or withhold taxes that you are responsible for managing yourself. If a broker begins to treat a contractor like a traditional employee, the legal classification can shift, leading to severe financial and administrative consequences. The Department of State utilizes a specific criteria often referred to as the three-prong test to verify this independent relationship. This evaluation focuses on the individual's ability to control their methods of work, the lack of defined shifts, and the absence of traditional employee benefits, such as paid health insurance or vacation time. A critical requirement for maintaining this status is the presence of a written independent contractor agreement, which must be signed by both parties and updated within the last 15 months. This document serves as the primary evidence of your professional arrangement in the event of an audit or a legal challenge. Prohibited practices under this status include a broker mandating floor time, setting strict office hours, or providing financial support that resembles a salary. When these boundaries are blurred, the integrity of the independent contractor classification is compromised, and the broker risks being held liable for back taxes, workers' compensation contributions, and unemployment insurance premiums. From a taxation perspective, the independent contractor status as a statutory non-employee is a precise legal category that requires diligence. You will receive a 1099 form from your broker at the end of the year rather than a W-2, reflecting the fact that no taxes were withheld from your commission checks. Because you are classified as a non-employee for tax purposes, you must account for your own earnings and set aside the appropriate funds for your quarterly tax filings. Failure to recognize the gravity of this responsibility can lead to significant problems during tax season, as the burden of compliance sits squarely on your shoulders. The law provides this freedom so that you can work as your own autonomous agent, but this autonomy implies a total lack of reliance on the brokerage for Social Security or unemployment benefits. As a professional, you're essentially a small business owner partnered with a broker, which necessitates a business-like approach to your income and expenses. The risk to the brokerage firm if they misclassify a salesperson is quite substantial, as it triggers an immediate investigation into their employment practices. If the Department of Labor or the IRS determines that an individual was actually an employee despite being treated as a contractor, the broker must pay the unpaid employer portion of payroll taxes. Furthermore, there is the lingering issue of workers' compensation and unemployment insurance coverage that should have been provided. For the licensee, the danger is that the brokerage may lose interest or confidence in maintaining that specific relationship due to the potential financial liability. Staying within the bounds of independent contractor law is therefore a shared interest between the broker and the agent to ensure long-term stability. By strictly adhering to the signed agreement and avoiding the imposition of employee-like controls, both parties protect the statutory non-employee status that defines our industry. I will see you in the next lecture. Welcome to this exploration of the regulatory consequences surrounding agency disclosure. Today, we focus on the specific enforcement measures under Section 443. When a real estate licensee fails to provide the mandatory agency disclosure form as required by New York law, the Department of State does not treat this as a mere clerical oversight. Instead, the failure to disclose agency status triggers a formal disciplinary process, where the primary risk is the loss of one's professional license. The Secretary of State maintains the authority to suspend or permanently revoke a license if they determine that a licensee has demonstrated untrustworthiness or incompetence. Administrative fines for these violations can be substantial, often calculated per occurrence, which quickly transforms a simple missed form into a significant financial liability. It is important to view these requirements not as optional paperwork, but as the foundational legal architecture of your professional practice. When a broker or salesperson skips these disclosures, they are effectively operating outside the scope of their legal immunity. Beyond simple administrative penalties, there exists a more nuanced legal concept, known as constructive fraud, that often arises from the omission of required disclosures. Constructive fraud does not require the intent to deceive in the traditional sense. Rather, it is established when a licensee breaches a fiduciary duty, creating a state of affairs that misled the client to their detriment. By failing to disclose agency, you create a legal landscape where a court may determine that you acted deceptively, regardless of your actual internal motivations. This has immediate and severe consequences for your ability to earn an income, as New York courts have consistently held that a broker who fails to disclose their agency relationship may be legally barred from collecting a commission. If you act as an undisclosed agent and are later challenged, you'll find that the law provides you with almost no shield to collect your fee, as the primary prerequisite for that fee is a transparent and properly established agency relationship. The disciplinary process itself is structured to provide due process, yet it carries the weight of a serious legal proceeding. Complaints against licensees are investigated by the Department of State, and if evidence of noncompliance is sufficient, the matter moves to a formal disciplinary hearing presided over by an administrative law judge. During this phase, you're given the opportunity to present your case, but the burden remains on the licensee to prove that the disclosure was provided in accordance with statutory mandates. If the administrative law judge issues a decision against you, it is not necessarily the final word, as there is a path for an Article 78 proceeding. This allows for judicial review in the Supreme Court of the State of New York, where you can challenge the administrative determination, though this is a costly and public legal route that most practitioners prefer to avoid entirely. Transparency is a hallmark of the Department of State's enforcement strategy, as all disciplinary actions are public and searchable within the state's licensing database. This means that a license suspension or a formal reprimand for failing to provide disclosure forms is effectively branded on your professional record for the public and potential clients to see. As a broker, you bear the non-delegable duty to ensure that every affiliated salesperson under your guidance adheres strictly to these requirements. You cannot simply claim that an agent was unaware of the rules, as the responsibility for systemic compliance rests squarely on the supervising broker's shoulders. Consequently, failing to audit the paperwork of your office is not just a management oversight, but a direct threat to your own brokerage license. Maintaining a culture of rigorous documentation is the only reliable way to insulate yourself and your associates from these regulatory hazards. I will see you in the next lecture. Welcome to our final review session, where we consolidate the essential knowledge required to pass the New York State Real Estate Examination. We will focus on finalizing your strategic approach to the test while anchoring the core concepts of Article 12A. When approaching the multiple choice section of a New York exam, your strongest weapon is the mnemonic Old CR, which effectively summarizes the fiduciary duties every agent owes to their principal. Let us review these components to ensure clarity: obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care. Many test questions will present a scenario where a conflict of interest arises, and your task is to identify which fiduciary duty has been breached or prioritized. Remember that the mandate for agency disclosure is strictly timed. You must present the disclosure form at the first substantive contact, which occurs before any sensitive information is shared. If you find yourself struggling with a question about dual agency, look for the requirement of informed consent from both parties. An agent cannot act for both the buyer and the seller without express, written permission, and failing this, the agency relationship remains legally compromised. Maintaining composure while reading these scenarios will prevent simple oversight errors. Regarding the legal definitions that often appear on the test, precision is paramount for vocabulary-heavy questions. Escheat refers to the state taking ownership of property when an individual dies without a will and without any known heirs, effectively reverting the title to the sovereign. Eminent domain is the government's power to acquire private property for public use, provided that just compensation is paid to the owner. Adverse possession occurs when a party claims ownership of land through continuous, hostile, and open occupation for a specific period of time set by statute. Lien priority typically follows the rule of first in time, first in right, though property tax liens and mechanics liens often take precedence over mortgage liens. Misunderstanding these terms can lead to losing points on fundamental questions, so ensure you view these as distinct legal mechanisms rather than interchangeable concepts. Lien priority is particularly important in foreclosure proceedings, as it determines which creditors are paid before others from the sale proceeds. The regulatory framework of Article 12A and the subsequent 2019 Housing Stability and Tenant Protection Act have fundamentally changed the landscape of rent regulation in New York. You must be prepared to identify that rent stabilization is a protectionist measure that limits rent increases and guarantees lease renewals, whereas rent control applies to a much smaller subset of apartments. A key takeaway is that the HSDPA of 2019 made these protections significantly more robust, limiting the ability of landlords to deregulate units upon vacancy or through high rent vacancy thresholds. In the context of fair housing, keep the nuances of New York-specific laws separate from federal standards, as New York often provides broader protections. For instance, local human rights laws in New York City extend protections to additional categories that you must be able to recognize on an exam. Discrimination in housing is never a matter of intent, as even seemingly neutral policies that result in disparate impact on protected classes will invoke legal scrutiny. Transitioning from a candidate to a licensed professional requires a systematic approach to the Department of State requirements. You should already be familiar with the 75-hour education prerequisite, but remember that your pocket card must remain current and must be produced upon demand. Once you have received your passing score notification, you'll navigate to the eAccess NY portal to finalize your application and pay the required fees. Ensuring your photo identification matches the documents submitted during the application process is a minor detail that causes significant delays for many unprepared candidates. Your status remains as an exam passer until the license is officially issued and associated with the sponsoring broker. Always verify that your active status is reflected in the database before engaging in any licensed activities, as conducting business without an active license is a violation of the very statutes you are being tested on. Good luck with your final preparations.